Hello and welcome to Weber Gallagher University. This is Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. My name is Paul Fires and I'm presenting today with my partner Jeffrey Lockyer from our Philadelphia office. Each month we present a current topic in workers' compensation legal issues. We present both case updates and ways to manage risk in your business. If you would like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website at www.wglaw.com. That's www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at wglaw.com. Today's presentation is Managing Opioid Abuse, New OSHA Rules, and the Blocking of Post-Accident Drug Testing. Next month, our topic will be Considering Medicare's Interests, Conditional Payments and Set-asides. Now let's get started. We start with building the case, using the workers' compensation system to reduce exposure in opiate abuse cases. Keep in mind, there's a role for everybody in this process. There's the role of the employer, the role of the carrier, and, most importantly, the role of the third-party administrator. The employer must watch these situations very carefully to first identify whether or not they have an employee who's engaging in any type of opiate abuse. And believe it or not, having knowledge and awareness of this begins even before the work injury. Unfortunately, there are many employers who have abuse issues within their employment pool, and that's something that's often noticed and that employers can become aware of through information that's shared around the workplace. There is an important role of a carrier and a third-party administrator because those are the people who watch and monitor the usage of opiates in cases. Keep in mind that severe, hardcore, and very high-level addiction-based drugs were originally invented for end-stage and terminal cases. They were also used primarily in acute cases, in cases of acute pain. When you start to see opiates used as part of a lifestyle decision and past the acute phase and without an indication of a terminal situation, you start to see red flags in many areas where there can be problems. So watching the usage of the opiates, identifying people who may have had past addiction issues is very important to inform the carrier and the third-party administrator of these issues so that appropriate observation, fact-checking, and action can be taken.
And hello everyone, thanks for joining us. What we're really talking about here specifically is an accepted workers' compensation case, a case where the carrier or the employer is already responsible for medical treatment. We're also going to assume that the use of opioids to treat chronic pain in a non-terminal illness setting is, at least in some situations, reasonable. So how do we set up our case, and what type of approach do we use to define our case as one that involves misuse or abuse? Well, you're going to have to take a multifaceted approach. You can't just look at it at one side of it. There's obviously you're going to look at the injured worker. You're going to look at how they are using medications, how their behavior complies with the standard acceptable behavior when using opiates. You're also going to look at the medical provider. It's a two-way street. The provider is often as much at fault as the claimant when it comes to how they're prescribing medications, what they're prescribing, and how much. And you're also going to look at the pharmacies. You can learn a lot specifically from studying where the claimant is obtaining any of their medications. A sign of misuse is getting them from numerous places. That's a real red flag. So those are the kind of things we're going to look at. We're going to look at how the claimant receives their medication, how they physically purchase it, what doses are they getting, and what providers, if there are multiple providers, are they getting medications from.
Let's start with obtaining the right medical evidence. The first and most important thing you can do is identify the appropriate medical expert. This would be a specialist in pain management and/or anesthesiology. This is the individual who will review the case, review the medical records, possibly even interview your employee, but not necessarily do that, and ultimately prepare a report detailing abusive medication use. These reports are based on modern day standards for the usage of this medication, the dosage of this medication, and whether or not the medication will prove to be effective or not. It is these specialists who spent years studying these issues, who treat people with these conditions, and are in the best position to identify when there is abusive behavior. But also an important step in this process is a proper communication with the doctor or doctors who are prescribing or in fact overprescribing some of these opioid medications. So what you want to do is identify a professional who is able to complete outreach with the prescribing physicians. Now, there are companies of all sizes and with all kinds of employee bases, and not every company would be equipped with that professional on staff, although some are in the form of a company doctor or in the form of a nurse case manager. But for smaller companies who don't have that type of physician on staff, usually a third-party administrator or a carrier will have physicians who can engage in this kind of outreach. Once you identify who this person is, it's important to consult with the prescribing physician about the findings, what was done by the specialist in pain management or anesthesiology. It is important to discuss safe and effective opiate reduction options with the physicians who are prescribing these drugs. It is also important to discuss the risk of prolonged opiate use in non-terminal cases. Oftentimes, when a physician who prescribes these drugs is made aware not only of these issues in general, but also of these issues and how they might be impacting your employee, they may think twice about what they're doing, they may become active participants in an opiate reduction program, and they may help with weaning. Also, please keep in mind that not everyone who is prescribing these opiates are in the pain management or anesthesiology fields. Sometimes they can be ordinary general practitioners, they can be orthopedists, they can be neurologists, they can be other kinds of physicians who are able to prescribe but not necessarily having the background or training to know the risks and the benefits of some of these prescriptions. We've seen in many of our cases that when they are enlightened by what is going on, some of them really are willing to work with you to make sure that if there is an overprescription issue and an abuse issue, that issue is turned around. And if they're not willing to cooperate, we're going to talk today about what to do about that.
Well, we've talked about a little bit about starting to define the behavior that you're trying to stop or reduce, and that's obviously the abuse or misuse of opiate medication. Mechanically, how do we do this in a workers' compensation case? Well, as we said earlier, we're talking about an accepted case. So what the first step would be is to obtain a utilization review of the provider that is issuing the medication. You're going to then get a decision back by the reviewing body that will either find the treatment reasonable and necessary, not reasonable and necessary, or reasonable in part. At that point, it's almost certainly going to be appealed by one side or the other. Once it's appealed, now you're in front of the workers' compensation judge, and the standard is whether the treatment is reasonable and necessary, and that's going to be reviewed by the judge de novo, meaning that he's basically free to accept new evidence on the issue. Where your expert report that Paul was just referring to comes into play with this is you can use that report to either support a favorable UR determination or to rebut a determination that was not favorable. So procedurally and from a litigation standpoint, that's where you're going to be. Now, what we're seeing is within the last year, the Center for Disease Control put out a comprehensive report on the proper time and the proper usages of opiate medications in chronic pain, non-terminal illness setting. So when you're arguing to a judge that something is reasonable or necessary, it really helps to have this report because what they ultimately found was in most situations the use of opiates is inappropriate. So now you've got some concrete federal government funded research that can help bolster your argument.
Let's talk about some red flags involving the behavior of a workers' compensation claimant who is engaging in opiate use or abuse. Number one, the claimant does not take the medication as prescribed. Number two, the claimant is prescribed more than the maximum dose due to obtaining prescriptions from multiple sources. Number three, the claimant obtains medication from multiple pharmacies, especially in close proximity by way of time. And number four, the claimant frequently requests additional medication from physicians due to pain. Any one of these red flags would require you to monitor this case closely for opiate addiction, but oftentimes we see two or more, and sometimes all of them taken together, as classic examples of red flags of a claimant's behavior. What do we mean that they don't take the medication as prescribed? It can really mean one of two things. Number one, they're taking way higher of a dosage than would be required or medically appropriate for the level of strength of the prescription. Number two, and unfortunately this happens as well, they might not be taking it at all because these drugs have a tremendous street value and they could be selling it on the street. So they could, as we indicate, be taking more than the maximum dose. And how do they often get the maximum dose? Typically not from the same doctor. What they may do is they may have a family doctor or general practitioner, and they may have a specialist, and they may even have a third doctor. And if they complain of pain, as we indicate in point 4, often enough, some of these doctors, without cross-checking, may be prescribing extra dosages. Whether they're taken or not remains to be seen. With the true addicts, they will be taken, and that's a problem. But even if they're not addicts, they may be getting access to these drugs and selling them for their street value. Again, the other red flag being watch for prescriptions filled in multiple different pharmacies, especially within the same month or length of time of a basic prescription. These are your red flags that you must watch for with claimants who are being prescribed opiate medication.
Now, as much as you examine what the claimant or the injured worker is doing with respect to their medications, the providing physician is also ultimately just as culpable when there's use or misuse in many cases. What the CDC did in their report in many ways, which was directed at providers, that was the target audience, was try to lay out certain guidelines that should be followed that would create an acceptable standard for how providing physicians should treat patients. So one of the first things they mentioned is that the doctor should at least inquire if the person is getting medications from another source. That seems common sense, but it doesn't always happen. And that is exactly the first step to stopping some of the problems that Paul was just referring to. Another delineated issue was doctors were not prescribing toxicology screens before they would prescribe an opiate medication. So it's nice to ask the patient if they're taking anything, but what you need to do is use either the state database to show what they're getting from other physicians, or order a toxicology screen to independently confirm whether this person is already taking some type of opiate once you're about to prescribe it. There's also a pattern of behavior the doctor should be following after they've started prescribing medication. They should be continually following up with intermittent toxicology screens, with efforts to reduce the medication whenever possible. And also, there's supposed to be an ongoing dialogue to explain the risks and harms to the patient and to document any possible benefits or lack of benefit that the person is getting from medications. It's not just supposed to be the patient comes in and they're continually prescribed the same medication over and over and eventually at increasing dosages. There's supposed to be some check on function, on pain levels to justify continuing the medication.
Let's talk a little bit about the weaning process. You may ask yourself, why is this important in the workers' compensation setting if you can possibly wean a UR and just have the drugs cut off? Increasingly, judges are becoming more and more aware of issues concerning withdrawal and what that can lead to in terms of the overall health of the claimant. Remembering that the Pennsylvania Workers' Compensation Statute is a remedial statute designed to benefit the workers' compensation claimant and to care for their health, weaning processes are something that's being talked about more and more by judges before they will consider cutting off benefits for excessive opiate use or cutting off the right to get more opiates. So keep in mind that many judges will prefer a weaning program formally offered to the claimant and formally offered to be paid for by the employer before stopping payment responsibility all at once when addiction or misuse issues are revealed. How do you get to a weaning program? You can get that prescribed by a pain management physician or possibly also by one of the physicians who are treating your injured worker and are in the position to offer such a program. There is growing recognition that if an addict does not want to wean, No program will be successful for that purpose. And while a good program that's inpatient can cost at least $30,000 a month, we must be very careful about not putting good money after bad and offering weaning programs or forcing people into them when we know that they will backslide as soon as they get out of it. Weaning programs work best with people who want to give up their addictions. They tend not to work well at all with people who are forced into the process. We're not saying, of course, that it will never work. It's just that your chances for success are substantially less. So ultimately, keep in mind that an appropriate medical expert should provide an opinion on an appropriate weaning program, including the incremental decrease of medications and the duration of the process. This is something that should be done in a non-adversarial setting, meaning that it's often important to get the claimant involved, the claimant's family members or other aspects of their support system if available, and of course, the claimant's attorney.
So now that we've laid out general guidelines and general rules for dealing with these kinds of cases, we wanted to go through a real example that we had here at Weber Gallagher that addressed just this very issue. So in our particular case, the claimant was a licensed nurse with an accepted injury to both knees from dealing with the patient. Approximately a year after the injury, there was a surgery to the right knee for a torn meniscus. In October of 2014, the employer obtained the expert report that we were discussing earlier with a board-certified pain management physician to address the narcotic medication that the claimant was receiving and that was beginning to become clearly problematic.
By December of 2014, a utilization review request was filed on the provider providing opioid medications. By January 10th of 2015, the utilization review found that all medications were neither reasonable or necessary, and this allowed the employer to stop payment of all medications. And please note, this was done without a weaning program. And we believe that the reason why this was done is because it was thought that this particular claimant was never taking the drugs but was in fact selling them for their street value. By March 5th of 2015, a medication usage report obtained detailed the claimant's aberrant drug behavior.
Now, what the expert, the employer's expert, learned in this case, and what he ultimately testified to, was that the claimant was being prescribed a tremendous amount of oxycodone over what the standard accepted dose would be. For opiates, each different type of opiate drug ultimately is broken down to its morphine equivalent when you're talking about doses. When it was looked at the amount of medication that was being prescribed, because the claimant was receiving them from multiple providers, the same exact drug, she was receiving 640 days worth of oxycodone in a period of 400 days. And the equivalent, the morphine equivalent, was well above what's accepted. We also learned from this report, and the expert testified, that the claimant was receiving her prescriptions from 9 different pharmacies. So when you're obtaining medication from that many different places, it's clearly a sign that the person is trying to cover up what they're doing. And then you see that she was being prescribed over 50% of what the accepted protocol was, and in reality what was going on, it would appear that it wasn't being taken at all, and that's why the dosage would apparently be so high.
Now, the claimant had a chance to provide witness testimony as well. So the claimant's expert ended up testifying on February 21st, 2016. And here's what we learned by cross-examining this witness. Number 1, the witness had never checked whether the claimant was receiving pain medications from other providers. Number 2, the witness was not aware of the claimant's drug screen, which showed that she was not taking her prescriptions. Number 3, the witness was not aware of the claimant's history of drug-seeking behavior, having obtained in 14 months 210 extra days of opioid-based medication from multiple providers and 9 different pharmacies. And despite eventually learning of all of the situation by way of this expert's deposition, the provider never ordered any kind of medical toxicology test at any time to check the claimant's use of her medication. And I should add that the doctor learned of this at the deposition and in advance. Because the doctor did not engage in any corrective behavior, this was noticed very clearly by the workers' compensation judge.
And as we've talked about throughout today, it really is a two-way street, and this case really illustrates that. You have the claimant's behavior, which is outside the accepted protocols, and you have the doctor. And the ultimate outcome was that the judge rendered his decision and found all ongoing treatment unreasonable and unnecessary with respect to opioids. The judge did not order a weaning program. The reason being, if you're not taking the medication as prescribed and it's being diverted somehow, you don't need to wean off of it. That's interesting because a lot of judges now, as Paul mentioned, they want a weaning program worked into a decision where they're stopping opiates. But this is one particular case when there's diversion that you don't see that. Another case would be if someone is taking a pain medication that's not an opiate. Well, some providers will tell you they should be weaned when stopping that. It's not necessarily true, and that's not what the literature is stating that. The judge also referenced CDC guidelines, and judges are referencing these CDC guidelines in their decisions as sort of a baseline. So it's important to know about them and to use them while litigating a case because judges find them important.
Finally, we'd like to make you aware of a rule that came down via OSHA during the term of the last presidential administration. OSHA determined that an employer cannot automatically mandate drug testing after every workers' compensation accident. Blanket post-injury drug testing policies can deter proper reporting of injuries because, and we can understand this from certainly one perspective, you may have drugs in your system from perhaps weekend use. And if you realize your job is at risk, you may not file a proper claim for a legitimate injury simply because of this drug testing policy at a particular employer. So what OSHA said was the employer must have specific reason to believe that the employee drug use is likely to have contributed to the incident. And if they have that reason to believe, they can order a drug test of an injured worker in this case. There is a pending action in the state of Texas right now to challenge this OSHA rule, and we'll see where this comes down. And we'll also see what OSHA does about this now that there is a change in administration.
Well, thank you all for attending today. We hope you found it enjoyable and informative. This was our webinar entitled Managing Opioid Abuse, New OSHA Rules and the Blocking of Post-Accident Drug Testing. Our next program will be on February 21st from our New Jersey office entitled Considering Medicare's Interest, Conditional Payments and Set-Asides. Our attorneys will review how to consider Medicare's interest for past treatment, conditional payments, and future treatment, set-asides, specifically in New Jersey, taking into consideration the difference between Section 20 settlements and orders approving settlement. You can learn more about this program and all other Weber Gallagher events at http://www.wglaw.com/WG University. Thank you.
Thank you.